Welcome to USA Justice Hub, where we explore the legal nuance surrounding trials, hearings, and legal proceedings. In today's episode, we're going to step inside the Harris County Criminal Court in Houston, Texas, where Judge David Fletcher has developed a reputation for cutting through weak evidence and holding the state to its constitutional burdens. Over several recent hearings, Judge Fletcher evaluated whether there was probable cause to justify criminal charges against 4 different defendants, with each case raising a different question about what the law actually requires before someone can be prosecuted. This episode will be part of an ongoing series dedicated to helping our viewers better understand how the concept of probable cause materializes in the courtroom, particularly when evaluated by a competent and impartial judge. Let us know if there are any probable cause cases that you'd like to see included in this series in the comments below. And with that said, let's dive right into our first case. On October 19th, 2024, defendant Ricardo Carroll was charged with assaulting his girlfriend in violation of Section 22.01A1 of the Texas Penal Code, which criminalizes intentionally, knowingly, or recklessly causing bodily injury to another individual. Section 1.078078 of the Penal Code defines bodily injury as physical pain, illness, or any impairment of physical condition. In a probable cause affidavit filed with the complaint, Deputy G. Brent of the Harris County Sheriff's Office explained that Mr. Carell's girlfriend reported that he had grabbed her left upper arm and squeezed it during an argument, and later pulled her hair and grabbed and squeezed her right upper arm during another argument. The affidavit also stated that Deputy Brent observed several bruises on her upper arms, and that she was shaking and cried while telling the story. However, Deputy Brentlinger reported that she told him that she did not feel any pain at the time of the incident, but that he knew from quote-unquote training and experience that being grabbed and bruises being left on the body causes pain. Defense attorney James Pons was appointed to represent Mr. Carell, and an arraignment was scheduled in front of Judge Fletcher on January 24th, 2025. Developer mode.
And then everything else that he's adding is not in that document.
To be more specific, she's saying she did not feel pain at the time of the incident since you were fighting. She didn't say she didn't ever feel pain. She said at the time since she was fighting the defendant off of her.
But the officer,
That's not in that.
But the officer. Yeah, sorry, Mr. Pons, I'm just.
The affidavit and she said she didn't feel pain.
I don't know. All I know
No, I'm
is
telling
that.
you. That's why I'm up here challenging the PC on that one. There's an affidavit, a complaint that's provided.
There's an affidavit because in the
Hey,
DIMS.
this is on Corral? This is a new case, right?
It's a complaint. So it happened in October 2024.
How did it get an affidavit here so quick?
Because it's a complaint. The officer's affidavit on the complaint. He states that she stated she didn't feel any pain because she was fighting him as well.
But you said that she did feel, you did feel pain.
Read both the complete DIMS.
I wouldn't, or that's the problem is the DIMS is maybe contradicting or inaccurate or different from the affidavit that I'm talking about. That the officer filed with the complaint.
So the complete DIMS reads, the complainant stated she did not feel pain at the time of the incident since she was fighting the defendant off of her, and that the officer observed the complainant shaking and crying, and the officer said, due to his training experience, I know being grabbed and bruises being left on her body causes pain. So according to the full DIMS, the complainant didn't say she felt pain. She said that she didn't feel pain at the time of the incident because she was fighting the defendant off of her. And that's what the full DIMS states. And the officer, based on training experience, saw the bruises on her and being grabbed and squeezed and came to the conclusion that it caused pain.
It could also be the exact, that what she said was, I was shaking and crying because I was fighting him. She's the one that says that.
I mean, I get it. Like at the time, you're in the stress and excitement, so you're not feeling it. But then after
That's not what she said though, or that's not what
Stress.
going on.
Your Honor, the key thing the officer observed were the bruises on the complainant's arm. He observed the bruising and then came to the conclusion based on that. And what she told him, she did say that the defendant squeezed her arm. And based on that, her crying, shaking, and the bruising, he came to the conclusion that she felt pain due to that being squeezed.
I mean, taken as a totality, is that not sufficient for probable cause purposes?
I don't know. You have a sworn document where she says one of the elements is missing. And then everything else that he's adding is not in that
To
document.
be more specific, she's saying she did not feel pain at the time of the incident since you were fighting. She didn't say she didn't ever feel pain. She said at the time since she was fighting the defendant off of her.
But the officer
not in that.
asked- But the officer never asked, hey, do you feel pain? Why
And
wouldn't you
because the
ask?
officer never asked, he tended to conclude based on totality.
Get it, but I don't know. I mean, I need to look up case law. I'm not sure. I don't know if that's enough. Because I mean, it's such a low standard for probable cause purposes, you know? I mean, I get that you're saying that it's not alleged the pain as an element, but taken as a totality.
I guess you're saying
No.
taking as a totality. I'm saying that's a lot of speculation about stuff that's not in the DIMS or in the affidavit. Like you're making all these connections state.
I'm making the officer made the connection. He said in the DIMS, due to my training experience, I know being grabbed and bruises being left on your body causes pain. So
Right.
he made that
You
connection.
don't operate on hunches.
Right. And she's also stated that I was fighting him. So that could be because of her
I
fighting.
mean, here's the deal. Like if I find no PC, right? They may just re-indict it though.
That's fine.
You know?
That's their.
Kelsey,
Yes, sir.
did you see what's going on? So in this case here, the officer never asks her, do you feel pain? He assumes she does just because of bruising on her arm. And because I guess they're in the stress of the excitement. So at the time she doesn't feel pain, but after a while, he assumes that she feels pain because of bruising on her arm.
And on body worn camera, he never says, we don't know.
But I mean, this is a probable cause hearing. We haven't seen it. So he wants me to find no PC. If I do though, right.
Well, if there are visible injuries, we can go from there.
But he's saying that, you know, I mean, if it were like blood, like some kind of tearing of the skin, that's one thing. But bruising, is it possible to get a bruise without feeling pain?
Yeah, do
You
it
know?
all the time. If you fall downstairs and you're embarrassed more than in pain, you might be crying or shaking because you're embarrassed or excited, but it's not because of you injuring yourself down the stairs.
But Your Honor, that also ignores that she did say the squeeze itself. He mentioning a fall, but in this case, we do have a specific statement about a squeeze.
She doesn't say that she's in pain because of the squeeze.
So
I
if we
mean-
play it out in front of a jury, you would always have that statement saying at the time she didn't feel pain. Whatever you said contradicting that, that's fine, but it would not take away that statement that eliminates an element.
That's my son.
So maybe a grand jury might find it different, but based on that DIMS, they have someone saying, I didn't feel pain. I think that's kind of like,
And Your Honor, I will say at the time, we don't have the full OR, so if you want to find no PC, we can revisit it. If we want to re-indict it, we can.
Okay, all right, I'll find no PC.
Mr. Pond argued that there was no probable cause to support the so-called bodily injury element of assault because Mr. Carell's girlfriend indicated that she did not feel physical pain and that there was no evidence that she experienced pain besides Deputy Brenninger's assumptions. Judge Fleer agreed, and he found that there was no probable cause to support the charge, and the state dismissed the case on February 5th, 2025. Our next proceeding involves defendant Jananisha Winbush, who was charged on September 26, 2024 with interfering with the duties of a public servant in violation of Section 38.15 of the Texas Penal Code, which prohibits interrupting, disrupting, impeding, or otherwise interfering with a public servant while they are performing a duty or exercising authority imposed or granted by law. The statute also specifically states that it is a defense of prosecution if the alleged interruption, disruption, impediment, or interference consisted only of speech. A probable cause hearing regarding the charge against Ms. Wisburn was scheduled for October 3rd, 2024, in Judge Fletcher's court.
You were charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On September 26, 2024, at approximately 1:15 p.m., An officer responded to a call at the TSU Library Center located at 3100 Claiborne Street in Harris County, Texas, regarding a disturbance. The officer made contact with the individual causing the disturbance, and the defendant approached asking officers what's going on and what did she do. The officers repeatedly asked the defendant to step back, and she became belligerent, asserting that they were at her store. She eventually complied and moved away, but she insisted that a police supervisor be called to the scene. TSU Sergeant Barnett arrived and spoke privately with the defendant. Afterwards, responding officer requested the defendant's information to report her behavior to her supervisor in the university. The defendant refused to provide it and attempted to bypass the officer. When the officer asked her to identify herself again, the defendant declined and attempted to walk away. As the officer tried to detain her, she began to throw herself on the ground and yell, escalating the disturbance. Several officers issued verbal commands for her to comply. The defendant continued to resist, jumping around and asserting her rights. The officer attempted to escort her outside. The defendant then wrapped her arms and legs around a pole, continuing to yell. The officers physically pried her from the pole and detained her. The defendant used her body weight to resist and push against the officers. The defendant was then placed in the back of the patrol car without incident.
What was she doing wrong?
So it appears she wasn't the initial person causing the disturbance, but when they came to respond to the disturbance that they were called for, she intervened. And once they asked her to remove herself from the situation, she refused.
You didn't say, when you initially started saying about everything, you didn't say that she was the initial cause of the disturbance, that there was a call for a disturbance. They get out there and she, I guess.
So what it says is that they made contact with the individual that was causing the disturbance, and then the defendant approached asking.
See,
the officer.
right. So she just comes up, starts being nosy, right?
Right.
And then she basically, I guess, is trying to leave. And then they start asking her for her information.
Well, they were asking her to leave the scene so that they can respond to the disturbance, and she wouldn't comply. I think that's the issue, that she wouldn't leave when they asked her.
You say that?
Yes. They asked her to move away from the scene and she refused to comply.
Show me, will you read that part again?
So when she approached the officers repeatedly asked the defendant to step back, and the defendant became belligerent, asserting that they were at her store. She eventually complied and moved away, but
So she complies, she moves away.
Right. But then she came back.
Okay.
And so at that point, when she returned, they asked her to identify herself. She refused to provide her identification. And then at that point, when they asked her to identify herself, she attempted to bypass the officers.
She leaves. She's trying to leave.
She is attempting to, she's attempting to leave again.
And then they start bucking up to her.
Sure, yeah.
Judge, what is this case?
It's on for tomorrow's docket. Let me give you the cause number. 251-1137.
Sounds like interference.
That's what she's charged with. But so sounds like she's got a case of the nosies, you know?
It's 2, 3, 1.
She goes up there allegedly being nosy. She leaves, comes back, and then they start asking for her information. And she declines to give her information.
So Judge, what I'm looking at here, just to add context to the situation, she approaches an unrelated incident. It looks like she's asking what's going on. Fine. They talk to her individually. Okay. They tell her to leave. She continually asks what's going on. What did she do? She asserts, she becomes belligerent is what the officer says, asserting that they were at her store. obstructing their investigation. Eventually, I don't know what the time frame is, but they say eventually she complies, moves away, but insisted that they need to call a supervisor to the area. A sergeant then spoke with her privately. After they responded and they requested her information to report her behavior to her supervisor at the university, and to identify her, which she refused to do. She then attempts to bypass officers. They ask her for identification again. They're detaining her. She says no.
But what's the interference? What did she specifically do?
Well,
She's just talking to them.
I understand,
Right.
Judge. She's talking to them, but she's saying that they're at her store. She's belligerent, telling them to leave. They're at her store. The position of the state judge is that did obstruct their investigation. I mean, it's not in this. There's multiple senses of obstruction in our opinion. It's not.
Are you losing right now? Okay. Yeah, I'm not buying it.
Okay.
I'm not gonna do it. All right, I'll find no problems.
I'll dismiss the case, Judge.
When you go up and you get into a pissing match with officers, who's gonna win? Who's gonna win? Every single time. If you go up and you mess with someone who has the power of arrest, you're going to lose every single time. Don't go. It's not hard. I found no probable cause in your case, ma'am. Just be careful. Okay?
Can I ask a question?
Sure.
If I want to press charges, or
Don't. You know what? Let sleeping dogs lie. Don't.
they assaulted me, though. They knocked out my tooth. They chipped my tooth. I got bruises on me.
And you can always go file a complaint with Internal Affairs,
That's what I'm
with
asking.
whatever.
How could I do that? I don't know the protocols.
So what agency was this? Is this, did you say it was at a college or?
TSUPD.
Okay. So you go to the Texas Southern University Police, you go to Internal Affairs, and you can file a complaint that way. Okay, I would take everything that you have, and that's how you do that. Okay, but just be careful.
And I can't really even go back to my job because they're trying to ban me.
I don't know. I mean, did they issue some kind of trespass warning?
No, sir.
If there's a trespass warning, be careful. I don't see that one has been filed. They haven't told me about any kind of trespass or anything, so just be careful, okay? But I found no probable cause. They're going to dismiss your case, okay? Just be careful in the future, all right, man? Okay, please. Good luck, okay, Ms. Wimbush?
After hearing the allegations against Ms. Winbush, Judge Fleer found that her actions did not rise to the level of interference with a public duty and determined that there was no probable cause for the charge against her. The state dismissed the case that same day. The next probable cause decision that we will review today also involves a charge of interfering with the duties of a public servant. Defendant Wawi Kemp was charged with interfering on January 26, 2025, for allegedly grabbing the arm of an EMS responder who was taking his mother, who was experiencing a medical emergency, to the hospital. Defense attorney Carolyn O'Corifer was appointed to represent Mr. Kemp, and a probable cause hearing was held in Judge Fleer's courtroom on February 6, 2025.
KEMP.
Okay. So what's the word, Thunderbird?
So upon watching the video, I agree with the defense, but it's not really clear. It's all happening at once where you see one moment, the defendant like lunge forward, but blocked. You can't see what he does. And then officers grab him immediately. So you really can't see the grab that the officer says in the OR that occurred. But in the OR, it says there was that grab, and that's why they grabbed him back. So
It's not there, it's not there.
Not there.
you just can't see. It's not saying it's not there. It's just that you can't see it on video. It's obscure. There's people in the way because
So I guess my theory from reading the notes is that when the whole situation was happening with his mother, the gurney was left outside of the house. So the EMS never came inside the house. They were asking the son who opened the door the mother has to walk outside. And he was like, my mother can't walk outside because she's having trouble breathing. Mom eventually comes outside, gets on the stretcher. The stretcher is then taken into the ambulance. The son is running after the stretcher because they're trying to make sure that their mom is fine. What the commotion that arises is that For me, I feel like nobody knew who exactly pushed who, but it's more of an emergency situation about a child caring for his mom who's having a serious medical issue.
I mean, times like this, when you have a medical emergency, right, it's always chaos. I mean, there's chaos ensues, right? Is he really trying to prevent an EMS person from doing their job?
So you look at the
Alex?
totality of the facts, it's like, how are you supposed to, how is he trying to prevent someone from doing their job when all he's trying to do is make sure that he's helping his mother, who they said, hey, we're not going to come to the house to even bring you in.
Did he pull the arm off?
According to the officer, he just grabbed it and the officer grabbed him at that point. So the reason why it's not really clear how quick it happened. On the video, it looks pretty quick because the officers grabbed him immediately.
But but the issue is that the officers arrived at the scene when there was already an incident occurring. They don't know, the officer can't state what happened initially.
Right, but the issue here is that as it's played, it's like the grab of the arm is that interruption or just disruption of the EMS trying to get the mother onto the gurney. And it's not necessary that the defendant intended to do that. It's just that there was that
This is a
disruption.
specific intent crime, so he has to specifically intend to interfere with the duty of that person, of the performance and exercise of what the official is trying to do. That's what he's charged with, right?
Respectfully, this is like criminal negligence. There's no intentionally knowingly requirement for this. It's just that a disruption occurred through the defendant's actions with criminal negligence. So in this case, he grabbed the EMS and the negligence would be that a reasonable person should have known not to do that, and that therefore resulted in the disruption of the EMS trying to perform their
But
duties.
the negligence also didn't pose a serious harm or threat. Like the EMS didn't appear to be threatened. I just don't think it's enough. I mean, even if they were to give us an offer, if we take this case literally to trial, the mom is going to testify as to what happened, including the brother and the dad, because they were also witnesses, which I spoke to all of them. I mean, I'm saying are we going to drag it? Because I just don't see it.
Our position would be that there's enough to move the case forward with probable cause. Whether there's issues for trial is another
I
issue.
mean, in that sense, he's right. I mean,
Yeah.
it's just a probable cause hearing. Is there enough to move forward? Because it's a very low burden, right? Yes, I agree with you. Is it enough to find someone beyond a reasonable doubt guilty? Perhaps not.
And I'm also basing my arguments as what is actually the evidence that we currently have to kind of figure out the confusion on what actually happened that night. I think it's not clear at all, which stuff.
It is not clear, so admittedly, our reliance is on the sworn statement by the officer in the DIMS.
So let's look up, because it says here, by grabbing EMS responders' right arm, interrupt, disrupt, impede, and interfere with Sanders, a person employed to provide emergency medical services, including the transportation. I'm sorry, this is what I'm looking at. Did then and there unlawfully with criminal negligence. What does criminal negligence mean? Let's look it up.
Yes, Judge.
The defendant should have been aware of a substantial and unjustifiable risk of harm. Is there substantial and unjustifiable risk of harm in this case?
One moment, Your Honor.
The risk must be so significant that it's a gross deviation from what a reasonable person would do.
I mean, I'm going to argue that if he was briefly grabbing the responder's arm, it does not create substantial or unjustifiable risk of harm. Meaning the fact that due to the nature of the situation, he was acting emotionally.
And Your Honor, if we're gonna go that, I respectfully ask for maybe 5 minutes to look in case law and see.
Take your time. There's no.
Yes, Judge.
Yeah, absolutely. There's no rush here. I mean, we got,
Yes, Judge, I respect 5 or 10 minutes and just to look at. case law.
absolutely.
Yes,
Take your
Judge.
time. Okay. Once and for all.
Yes, Judge, and after reviewing the video and reading case law where there's a case Duncan v. State where they describe it as essentially shutting down even we looked at it, we don't see that here.
Okay, I'm gonna find no problem.
Yes, Judge.
All right.
Yes, Judge.
All right,
Your Honor.
good job.
Thank you. Thank you.
And I'm gonna tell you, look, from what I read, I was looking at case law as well too, and it said the gross deviation is such that like, there was a guy who had a trailer, right? Who didn't put chains on the trailer detached, it was a homemade trailer, it detached and it killed someone. That's a gross
That's why I
deviation, you know what I
posted the
mean?
video and it was just
Yeah.
very brief. Yes, Judge.
You have enough cases.
Yes, Judge.
Thank you, Your Honor.
Thank you.
After reviewing the body camera footage from Mr. Kemp's arrest, case law, and the interfering statute, which requires that the defendant act with, quote, criminal negligence, as defined in Section 6.03 of the Penal Code, the prosecutor agrees that Mr. Kemp's actions in briefly grabbing the EMS worker's arm did not constitute a gross deviation from that ordinary standard care that created a substantial and unjustifiable risk of interrupting, disrupting, impeding, or interfering with the public servant's duties. Accordingly, Judge Fleer found that there was no probable cause, and the state dismissed the charge the same day. The final proceeding of this episode involved defendant Samuel Duoto, who was charged with theft on July 26, 2023. Mr. Duoto was released on bond, but then failed to appear at a scheduled court date, and a bench warrant was issued for his arrest. On September 13th, Mr. Duoto was arrested and charged with an additional offense of failure to identify under Section 38.0202 of the Texas Penal Code, which makes an offense for an individual to intentionally refuse to provide their name, address, or date of birth to a peace officer who has lawfully arrested them, or to give false identifying information after being lawfully arrested, lawfully detained, or witnessing a crime. Mr. Duoto was charged with giving false information after being lawfully detained. Mr. Duoto failed to appear at another court date, and on June 18, 2024, he was arrested again. On June 21st, a bail review hearing was scheduled in Judge Fletcher's courtroom, where Mr. Duoto was represented by defense attorney Alan Williams, Jr.
Oh, come on, they charge him with theft because he's trying to charge his phone?
No, they didn't charge him with that, Your Honor. This is the.
I know, but that's the contact to get to him. All right, come on up. Hi, Alan. Tell me, what's up?
See if we can get PC for Samuel Duto.
Okay,
I want to see if we can get PC for Samuel Duto.
okay, sure.
Here on September 13th.
Okay, hold on. Just way too loud. Okay, so is he in custody?
Yes, he's currently in custody.
So he's got two cases. He got the theft and the failure to ID.
Yes.
Which one are you challenging?
Failure to ID.
Okay. On September 13th, 2023, at approximately 3:22 in the morning, officers were conducting routine patrol at 7-Eleven. In the alley behind the 7-Eleven, which is a common place for drug activity, graffiti, panhandling, and transits hanging out. They noticed a person using the wall plug-in on the outside of the business to charge his cell phone. Officers made contact with the person and identified and asked for his identification. The suspected charge is theft of a service under Penal Code.
Oh, come on, they charge him with theft because he's trying to charge his phone?
No, they didn't charge him with that, Your Honor. This is the.
I know, but that's the contact to get to him.
Yes.
There's nothing mentioned in that in the report. When they approached them, there was no indication that the owner said that they didn't have permission to be there. There was no indication to say that they did not receive permission to charge their phone. They approached them for what?
Your Honor, it's not common that a store clerk would offer someone the opportunity to charge their phone in the alley behind the 7-Eleven as opposed to within the 7-Eleven itself.
Just because it's not common doesn't mean that you can't have it.
And so what, so they go up to him, they start talking to him,
He identifies himself as Vinny Mancuso, birthday 3/19/1991. Then he said his name was Samuel Mancuso, same birthday. He was unable to verify each one of those, and another officer eventually located his wallet and identified himself by his true name, Samuel Duoto.
They were doing nothing.
The defendant had outstanding warrants and was placed in custody.
They was.
He was charging his phone.
what do you think? Charging his cell phone, so they come up to him and they start talking to him, and then, I mean, come on. Do we need help back there?
It's like an adult, and I can treat you better.
You all right back there?
Yeah, he's fine. He's just upset because he wants to go now. Yeah, he's not getting his way.
Who is it?
I don't even know. The attorney told him he was done, but I don't know about it.
Okay.
Tyler? Probably. No, it's not. Let me see.
Talk to Pavel. Let's see.
Judge, we would, we'll defer to the court. I mean, he didn't have a warrant for his arrest, so.
I mean, he's stuck anyways, right? Because the theft is good. He's not going anywhere, right, on the theft.
So. The way it's charged, it sounds like it's PC, but we'll defer to the court. Because he had a warrant for his arrest. I mean, that's.
Do you want to do something with it today anyways?
We weren't. We had something worked out. I didn't like the fact that,
because it might happen anyways.
I wanted time served. I wanted the time served. He offered, he would have to do 24 more days.
I'm okay with that, or I'm okay with whatever you want.
Okay.
It's up to you guys.
Yes, Your Honor. I'll always defer to Pavel with things that, after 90 days, depends once time served.
Okay, and I'm totally fine with that too.
Okay, thank you. All right,
thank you.
We'll came up. Thank you.
Hey.
Later that day.
Alan. Okay, so first we have, is this Rivera and Soto?
With the D.
Oh,
I know I mispronounced it, so. Pronounce it one more time? Duto.
Be careful when you charge your phone. You now know they're gonna mess with you anytime, even going to a 7-Eleven, you know what I mean? Be careful, right? So, sir, you're charged with 2 cases. You're charged with failure to identify oneself. You're also charged with theft. Alan, what are we doing on this?
I believe we're going on the failure to ID and dismissing the.
Dismiss the theft?
Yes, Your Honor.
Okay, that is a fantastic deal, Mr. Duato. I hope that you understand this and appreciate it. You know, most times people plead to the theft case and it really hoses them. Because then you're looking at, you know, federal, or not federal, but felony time next time. So you're charged with failure to ID. It's up to a year in jail and or a $4,000 fine. They've offered you time served. What time are we looking at?
Rojas?
No, Duato.
Oh, 18-6.
18 days in jail, credit for the 6 days that you've done. You're giving up a lot of rights by entering this agreement, and same goes with you, Mr. Rivera. You both give up a lot of rights by entering these agreements. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never change this or undo this. Now, Mr. Rivera, you're charged with assault of a family member. You need to understand that this comes with an affirmative finding of family violence. What that means is that if you ever pick up another one of these cases, you'll be facing a 3rd-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. Do you understand? Have you ever been to prison before? It's not a fun place, man. You can never own a gun or ammunition as a result of this plea bargain agreement as well. You picking up a gun is a Class A misdemeanor in and of itself, okay? What time are we looking at on Rivera? 21/7? Okay, so it's 21 days in jail. Credit for the 7 days that you've already done. How do you plead to the offense, sir? Guilty or not guilty? I will find you guilty, sir. And Mr. Rivera, how do you plead? I will find you guilty as well. I will roll both of your court costs so you won't owe anything, and good luck to you guys. All right,
gentlemen, go ahead and go through that door for me.
Although Judge Fleer expressed doubts that Mr. Duoto had been lawfully detained when he provided the false names, he did not enter a finding of no probable cause in this case. Instead, Mr. Dotto accepted a plea agreement where he pleaded guilty to the charge of failure to identify in exchange for the theft charge being dismissed. These proceedings highlight how probable cause serves as an essential constitutional safeguard in the criminal process. In each of these hearings, Judge Fleer closely examined whether the fact alleged actually satisfied the legal elements of the offense charged, whether bruising without pain was enough to establish quote-unquote bodily injury, whether verbal opposition or brief physical contact truly amounted to so-called interference, and whether an individual who provided a false name the police did so during a detention was supported by lawful authority. And several of these cases, the evidence simply did not meet the statutory requirements, and the charges were dismissed before trial. These outcomes demonstrate the importance of judicial oversight at the earliest stage of a criminal case, ensuring that citizens are not prosecuted without sufficient legal or factual basis. As these examples show, the probable cause determination is more than just a procedural formality. It is a critical check on the power of the state, reminding both law enforcement and prosecutors that every criminal charge must rest on solid, legally sufficient grounds. Let us know if there is a case or courtroom interaction that you'd like us to explore in the comments down below. Thank you for watching, everybody, and don't forget to like and subscribe so that we can help foster a more informed society.